All right, let's get right into this explainer, where we are going to impartially dissect a really intricate alternative legal playbook detailed in our sources. The materials we're looking at today outline a highly complex, totally unconventional framework that directly challenges the very foundations of the American judicial and financial systems. Honestly, even if you're just a casual observer of the legal system, understanding the sheer mechanics of this kind of fringe resistance provides a totally fascinating look into how some people are attempting to completely rewrite the rules of courtroom engagement. So we're going to explore this step by step, unpacking exactly how this strategy supposedly operates, from its foundational philosophies all the way up to its tactics for international escalation. Now, according to the sources, this bold claim is the foundational premise setting the stage for a sprawling worldview about debt, courts, and systemic workarounds. The strategy fundamentally argues that actual money, as we think of it, doesn't really exist in the current system. Instead, it claims that citizens themselves, specifically their signatures, act as the collateral and the credit line that actually funds the government and the courts. And if you understand this premise, you understand the engine driving everything else we're about to look at. Because if there is no money, then every court case isn't actually about law, it's entirely about commerce and debt. To navigate this dense labyrinth, here's our roadmap. 1. The hidden court system. 2. The estate and the bond. 3. Courtroom reversal tactics. 4. Exposing financial conflicts. And 5. Escalating to global authorities.
Okay, Section 1. The hidden court system.
Let's start with the central worldview of the strategy, which claims there is a massive, hidden jurisdictional schism in the American justice system. The strategy argues that most modern courtrooms secretly operate as corporate Article 1 courts run by so-called foreign agents. For example, if your name is spelled in all caps on legal documents, they argue you're actually being pulled into a corporate, territorial jurisdiction. Think places like Puerto Rico or Guam, administered by officials who have allegedly renounced their American citizenship. Contrast that with the lowercase, organic republic under Article 3, which the sources claim is the true venue for constitutional rights. The playbook basically insists that officials deceive everyday citizens by wearing both hats, appearing as constitutional judges while secretly running an administrative, purely corporate process.
Moving right along to Section 2, the estate and the bond.
Digging into the financial mechanics, the strategy insists that because real money supposedly doesn't exist, court cases are actually administrative attacks on a citizen's personal estate. The absolutely crucial point here is that the sources characterize every single action by a judge or prosecutor as an attempt to raid that estate without filing the proper tax documentation. The strategy dictates that when court officials charge you, they are essentially acting as qualified heirs, trying to extract value from your all-caps corporate estate. But here's the catch. Under Title 26 of the tax code, to avoid personal liability for the taxes on those extracted assets, they supposedly must put up a massive security bond, sometimes cited as no less than $100,000 per case. If they can't produce this bond, the sources claim they are actively committing Section 7201 tax evasion, which is a federal felony.
To really hammer this home, the source uses a fascinating Price is Right analogy to argue that officials must be forced to assume the tax liability for the assets they're allegedly seizing. Imagine you're on a game show and you win $100,000 in prizes. You're absolutely thrilled until you realize you have to pay $10,000 in taxes to actually claim them. Well, the playbook argues that judges and prosecutors are the ones claiming the prizes from your estate, but they are trying to bully you, the original beneficiary, into paying the massive tax liability on the back end. This metaphor perfectly encapsulates the whole defense strategy, forcing the financial liability right back onto the court officials.
All right, Section 3, courtroom reversal tactics. So how does the playbook recommend you actually fight this in a courtroom? Well, the strategy uses the Power of Appointment Act of 1951 to forcefully reassign the judge and prosecutor from beneficiaries to fiduciary trustees. The source claims that courts basically operate under trust law, using a holy trinity structure made up of a grantor, a beneficiary, and a trustee. Now, usually the court sets itself up as the beneficiary and forces you into the role of the trustee, meaning you bear all the liability. The playbook instructs you to flip this script entirely. By invoking the Power of Appointment Act, you declare yourself the executive and beneficiary of your estate, and you legally appoint the judge and prosecutor as your trustees. Once you've done this, the strategy says you simply order them to discharge the debt, and then you remain completely silent so you don't accidentally forfeit your new status.
To enforce this power shift, you are instructed to basically trap the officials on the record by asking 5 exact, combative discovery questions regarding their alleged tax liabilities and bond status. The sources advise that these questions are meticulously designed to be unanswerable by the prosecution without admitting to fraud. By asking them to prove they have put up a bond for their tax liability on your estate, you are boldly challenging their fundamental right to even be in the courtroom. If they refuse to answer or can't produce the bond, the strategy claims you've successfully proven a breach of contract and exposed their tax evasion right there on the public record.
Let's look at Section 4, Exposing Financial Conflicts. Outside of the courtroom, the source outlines an all-out administrative war designed to prove that judges are practicing off the bench in violation of Title 28, Sections 454 and 455. The strategy claims you've got to follow exact steps to obtain financial records that prove the judge is illegally receiving a bribery check from the county side. Because the playbook defines judges as foreign officials operating under corporate jurisdictions, it argues they literally have no right to receive local county funds. So, to prove they are, you're instructed to march down to the county comptroller, demand the specific balance sheet for your case number, and then certify that document in a federal district court. Finally, you drop an affidavit of motion Pro 73B into your case. This is essentially a formal, highly documented demand for recusal based on a financial conflict of interest. According to the sources, presenting this proof will force the judge to either step down immediately or face disbarment and actual prison time.
But what happens if the comptroller's office refuses to hand over the records? The source advises threatening them with a Title 42 lawsuit for violating your due process rights. The strategy completely anticipates that local clerks might try to play games to protect the system. So by threatening a federal civil rights lawsuit directly against the clerks or their supervisors, the playbook claims you can leverage their fear of losing their jobs, effectively forcing them to hand over the financial balance sheets required to spring your trop on the judge.
And finally, Section 5, Escalating to Global Authorities.
The sources provide a highly specific arsenal of IRS forms meant to trigger federal audits and formally accuse court officials of breach of contract and tax evasion. Because the entire strategy hinges on the idea that the court is failing to pay taxes on your estate, the IRS literally becomes your weapon. You use a W-9 to demand the judge's tax ID. Use the 3949A to report them for criminal tax violations for not having a bond. You even submit a Form 211 to act as a formal whistleblower. It's wild. The playbook relies heavily on the sheer bureaucratic weight of these filings to terrify risk management officials behind the scenes.
If local risk management fails to act, the strategy dictates escalating the paperwork chain all the way up to Interpol in France and the International Common Law Court of Justice. The sources instruct you to start locally. You notify the head sheriff that the judge is committing a felony and demand their arrest. When the sheriff predictably does nothing, you escalate. You send your IRS forms to the Treasury Inspector General and the State Attorney General. And if the domestic authorities entirely ignore you, the playbook claims you just bypass them completely, sending your documented proof of tax evasion and civil rights violations to international authorities, hoping global pressure will force the local system to collapse.
This whole thing leaves us with a genuinely fascinating question about the intersection of obscure legal philosophy and the sheer weight of bureaucratic paperwork. Whether viewed as an elaborate legal fiction or a hidden truth about commerce and justice, the strategy outlined in these sources relies on overwhelming the system with its very own rules, forms, and financial liabilities. By attempting to force judges and prosecutors into the role of tax-evading trustees, this playbook illustrates a highly organized, alternative understanding of the law. Just imagine the sheer gridlock if everyday citizens adopted this kind of paperwork warfare on a massive scale. What happens to the daily machinery of the courts if this specific, document-heavy resistance spreads like wildfire? It's a pretty compelling thought to end on. Thanks for joining me for this explainer, and I'll catch you next time as we continue to unpack complex topics.